The commitment to the care of the minor children, although it's in the clean break principle, my view is that if the children is with the wife, for instance, she needs to have the means, as we already discussed, like a vehicle, for instance, to take the children to school. Minor children maintenance, in general, under Rule 43, maintenance for the children, it is important that they are taken care of. As maintenance for minor children is very important. And when a settlement agreement is concluded between the parties, there must be specifics in terms of school, university, medical, all those needs of the children. Because I've had arguments in court where the other party would say it's not written there. And so that's why I try to elaborate it as possible in terms of the maintenance payable for the minor children, or any maintenance payable for that matter. I'm talking about a decent agreement that provides clarity on who receives what maintenance, when, why, and for what, and so forth. That's important. I'm even talking about when the children visit. Now, for me, that's also children maintenance, because taking of the care that when the child is visiting a parent, that is maintenance in the sense that it is the maintenance of the human, of the person. It's important that that child will visit the father for so many days during the mid-year holidays, and the mother so long, or they alternate, and so forth. And what happens when the mother needs to see the child for Mother's Day, because she's entitled, when the father is actually supposed to have the child, but because it's Mother's Day, she's entitled to have the child. Those are the type of things that you write. If you don't write it in your settlement agreement, then if it's the father's weekend and it's Mother's Day, so be it. It's not in agreement. You cannot enforce it because it's Mother's Day. You'll say, yeah, but why is a person so rude? It happens. People use children to fight their own battles. Yeah, and calculating the maintenance, you need to look at the means of the person paying the maintenance. Then you also need look at the requirements of what the children need. It is unfortunate that you've got from the poor to the wealthy, and the children are being maintained in terms of the means of the parents. However, in divorce proceedings, often you'll find where a person is wealthy, they will actually try and diminish the value of the support they want to give to the children. That is where the problem comes in with calculating the maintenance. The children's needs might not always be satisfied in terms of what can be paid or what is payable, and we have to distinguish that. Sometimes the one party might actually go into incur debt just to provide the children with what they are used to, or just to provide for the children because they are not getting any maintenance or hardly any maintenance. That is where calculating the maintenance is important, and especially when you're making application for Rule 43. If the woman comes to you and she says, yeah, but this man earns 100,000 Rand a month, get his pay slip, but he might earn 100,000 Rand and he's got to pay 110,000 Rand. The court still will consider that the children must be maintained. The children's maintenance are more important than the debt. The court will consider his debt, but also they will, first and foremost, as upper guardian of the minor children, look after the children. And if they can't really look after the children, then obviously the family advocate's office through the social services will take the appropriate action to make sure that those children are cared for. This is a very tricky one, calculating the maintenance, but it shouldn't be, especially if the parties have sufficient means, monetary means, to look after the children. The children might not always get what they used to, but at least they will be taken care of. As you can see at the bottom, also when assisting your client with the preparation of the settlement agreement is also stating when this maintenance will come to an end. Just on that point, when especially with rehabilitative maintenance, okay, token maintenance will be forever, or else when the person remarries. And then especially also with the children, when they go to school, some settlement agreements I've seen I just want to laugh at, because the moment the child turns 18, they stop paying maintenance. But if you've got a clever settlement agreement, it will say when the child reaches 18 or at the completion of the child's school. However, a child is also entitled to any first qualification they're entitled for the parent to pay for that. No subsequent education needs to be paid by the parent. That is where their responsibility stops. But that should also be added into the settlement agreement, and also extramural activities, additional activities, because if those activities are not in there, the person paying the maintenance don't have to pay it. If the child was doing horse riding, for instance, then that must be in there for that time frame, and it doesn't matter when it expires, but at least it's in there, and the expiry of that is managed so that the child's needs are being taken care of. It's always about the child. It will never be anything about anything else. Yet it also says, once a child obtains higher qualification but wishes to continue their studies, it can be fair to expect the child to first obtain employment and continue with part-time studies. So that is that further additional education. Unborn children, they also entitled to maintenance. We all learned about it in our Sutrist fiction of the unborn child that also have rights. When the child is born after the divorce, then that child is entitled to maintenance. I do expect a person in such an instance to actually do make provision, although that child will be automatically entitled to maintenance. But it's good to always make provision for that, because otherwise, if there's maintenance, say 5,000 rand for a child, then the father might decide, listen, I'm paying 5,000 rand, there's no specific amount, I'll give you 500 rand for the second child, because there's no specific element that prescribes the maintenance amount. For instance, should the child be born, what maintenance that child should actually also receive, and that maintenance should be similar, obviously dependent on age, the child that might already receive maintenance. So it's also dependent on if there's a first child or a subsequent child born from the marriage. Here's an interesting one where an unwanted birth, that child is also entitled to maintenance. Doesn't matter if it was a botched up sterilization or there wasn't proper preventative measures between the parties, that child that is born is entitled to maintenance. Or just giving you an indication of unborn children, if there's no provision for such a child, it can end up in court again with unnecessary litigation that the mother will have to go through, especially if she doesn't have the money. And you can think about it, it costs a lot of money when a child is born, and the maintenance of that child, especially when they're so young. If the child is ill from birth or they need formula, that consumes a lot of finances, and if a person can't afford it, why not rather make provision in such an instance that the settlement agreement post-divorce, and when the child is born post-divorce, that there's provision for that child. You can see artificial fertilization is also a situation where the child needs to be maintained by the father unless he did not consent to the artificial insemination. That's the only time that he doesn't need to actually have a duty of paying maintenance towards the minor child. Children born out of wedlock are not excluded. Maintenance need to be paid for them. However, sometimes a person will fall pregnant, and then she will say, this is the father, but the father needs to do paternity tests. Some fathers don't want to do paternity tests. They say, it's not my child, but obviously that is a battle that has to be fought in court, especially if the person insists on seeing the child, but then he must go for paternity tests, or he must submit that he is the father. It does happen. Where the parents of the children are not married, it's advised that they have a parenting plan. Because if we have a situation where the one parent wants to see the child that is not the primary caregiver or does not have primary residence, then the other party can actually do as he or she wish, and then this person will have to run to court or go to the police and say, but I can't see my children. Where there's no parenting plan, that's not an order of court, the police will not assist you. Rather get a parenting plan that's approved by the family advocate in conjunction with the report from the social worker. That parenting plan gets made in order of court, and it is similar as if there's a settlement post-divorce in place because the children are taken care of. So basically, the parenting plan can contain everything that's in the settlement agreement, that will put in the settlement agreement. Obviously, some of the wording will be different, and there will be no maintenance payable to the mother for her, for instance, because she's most probably working. But however, she will be paid maintenance for the children so that she can take care of the children. As an example. In Carstens versus Carstens and O versus O, especially Carstens versus Carstens, the court held that when there is separation of issues, there are issues that are still outstanding. And if those issues have not been finalized, then the divorce in totality hasn't been finalized. In other words, there are issues outstanding. And Rule 43, for instance, makes provision that interim maintenance under Rule 43 is pendente lite. In other words, litigation is pending. And when there are still issues outstanding on pending litigation, then the court held that the plaintiff should be paid maintenance still, whatever they've agreed upon, or what the court actually orders. In our view, there are also judgments, as I said, apart from these two, that states that there can be post-divorce interim maintenance pendente lite.